Hi everyone, I'm Adriana Giometti, Chief Marketing and Client Relations Officer at Holman Webb. With COVID-19, we're all experiencing some intensely challenging times. To help you navigate this, we've developed the Legal Lockdown series, where I'll be speaking to lawyers across the firm and other experts whilst in lockdown about issues, opportunities and reforms that are significantly affecting the way we do business across the country. Alicia Mataere joins me today. She's a special counsel in the workplace relations team at Holman Webb. Alicia, could you shed some light on the JobKeeper Scheme?
Hi, Adriana. Yes, so the federal government's JobKeeper Scheme, which we've been hearing about for quite some time, has now been introduced to Parliament and passed. It's a $130 billion initiative that provides a $1,500 per fortnight payment to employers to supplement the wages of permanent staff and some casuals as well. The scheme also provides employers that qualify for it greater flexibility in terms of how they manage their workforce, as it's introduced the concept of JobKeeper directions. They allow employers to vary an employee's days, location of work, and duties in circumstances where they may not agree. So there are obviously some qualifications to that, given that they're without agreement. So there's consultation requirements, written notice requirements, including some fail-safes if that isn't complied with, including heavy penalties for employers as well if they get those directions wrong. I think a further initiative that was introduced, again only applying to employers that qualify for the JobKeeper Scheme, is the ability to take annual leave at half pay. So some employers would have already entered into agreements for that. My reading of the legislation is that it's not retrospective and does only apply to those employers who will qualify, but it does provide some certainty around half pay for annual leave that won't breach other provisions of the Fair Work Act.
Okay, so what about the instance where you have an employee that's earning around $500 a week? They're now being bumped up to $750. Can an employer ask that employee to work longer hours?
Yeah, absolutely they can. They can ask them to work additional hours to cover those additional monies. The only thing employers need to be aware of is that in doing so, they may then have to pay those employees at overtime rates because they're working additional hours to what has been agreed, which may ultimately work out to be more than the $250 gap there.
Yeah. Yeah. So the other question, I guess, is what about when you have an employee who just isn't coming to the party, won't take less pay, won't cut their hours? What recourse does an employer have there?
Yeah, look, that's, I think, really difficult for employers to manage. And, you know, employers at this point are having really difficult conversations with their employees and really trying to win their hearts and minds and get them on board to get everyone through this time. And for those employees that just won't change for whatever reason, I think employers really need to become creative in thinking of new ways in which they might be able to convince them to come on board. But I think, at least from our experience in dealing with our clients, a lot of employees are wanting to maintain their jobs, even if it is at a reduced rate or reduced hours. We've all seen the queues at Centrelink, and I think most people will want to avoid that if they can.
Exactly. So, you know, a last resort potentially could be a stand down or a redundancy provision. What's the difference between the two?
Yeah, look, there has been some confusion definitely around the two, and it's probably easiest to think of them in terms of a stand down is an employer essentially hitting pause on the relationship, whilst redundancy is where the relationship is ended altogether. So I think they're two really good points to make. The other thing is that stand downs aren't under the Act aren't a convenient way of avoiding economic loss. There are additional requirements that employers need to meet as well before they can rely on those provisions.
Okay, so other than the JobKeeper Scheme, what other changes are we potentially going to see to the Fair Work Act as a result of COVID-19?
Look, the JobKeeper Scheme is in place, or the amendments to the Fair Work Act, they have an end date of the 28th of September. Other, I guess, changes to workplace which we've seen apart from JobKeeper has been the Fair Work Commission amending, I think from memory, 103 modern awards of its own on its own initiative, and that's been providing for pandemic leave, which is 2 weeks unpaid leave to all employees, regardless of whether they're casual or permanent, and also amendments to enable employers to agree with employees to take annual leave at half pay. So removing that concern around breaching the Fair Work Act for not having paid an employee at the full rate for the annual leave. That's been overcome by amendments to the awards if your employees are covered by it.
Okay, so we'll have our fingers crossed for the 28th of September for D-Day, right?
Yes. Hopefully it's a day of celebration for everyone and lockdown will be over.
Thanks for your time, Alicia.
Thanks, Adriana. Take care.